You're listening to the Valley Current.
That's interesting. But of course, AI could read your source code and my source code and 40 other source codes. And then it could decide which compiler to use. And it could merge all the results of all the compilers and improve the product, maybe.
Yeah, I mean, let's play this for a second.
What do all recent super powerful image models like DALL-E, Imagen, or Midjourney have in common? Other than high computing costs, huge training time, and shared hype, they are all based on the same mechanism, diffusion. Diffusion models recently achieved state-of-the-art results for most image tasks, including text-to-image with DALL-E, but many other image generation-related tasks like image and painting, style transfer, or image super resolution. Though there are a few downsides. They work sequentially on the whole image, meaning that both the training and inference times are super expensive. This is why you need hundreds of GPUs to train such a model and why you wait a few minutes to get your results. It's no surprise that only the biggest companies like Google or OpenAI are releasing those models. But what are they? I've covered diffusion models in a couple of videos, which I invite you to check for a better understanding. They are iterative models that take random noise as inputs, which can be conditioned with a text or an image, so it's not completely random. It iteratively learns to remove this noise by learning what parameters the models should apply to this noise to end up with a final image. So basic diffusion models will take a random noise with the size of the image and learn to apply even further noise until we get back to a real image. This is possible because the model will have access to the real images during training and will be able to learn the right parameters by applying such noise to the image iteratively until it reaches complete noise and is unrecognizable. Then, when we are satisfied with the noise we get from all our images, meaning that they are similar and generate noise from a similar distribution, we are ready to use our model in reverse and feed it similar noise in the reverse order to expect an image similar to the ones used during training. So the main problem here is that you are working directly with the pixels and large data input like images. Let's see how we can fix this computation issue while keeping the quality of the results the same as shown here compared with DALL-E. But first, give me a few seconds to introduce you to my friends at Qwak sponsoring this video. As you most certainly know, the majority of businesses now report AI and ML adoption in their processes, but complex operations such as model deployment, training, testing, and feature store management seem to stand in the way of progress. ML model deployment is one of the most complex processes. It is such a rigorous process that data scientist teams spend way too much time on solving backend and engineering tasks before being able to push the model into production, something I personally experienced. It also requires very different skill sets, often requiring two different teams working closely together. Fortunately for us, Qwak delivers a fully managed platform that unifies ML engineering and data operations, providing agile infrastructure that enables the continuous productization of ML models at scale. You don't have to learn how to do everything end-to-end anymore thanks to them. Qwak empowers organizations to deliver machine learning models into production at scale. If you want to speed up your model delivery to production, please take a few minutes and click the first link below to check what they offer, as I'm sure it will be worthwhile. Thanks to anyone taking a look and supporting me and my friends at Qwak. How can these powerful diffusion models be computationally efficient? By transforming them into latent diffusion models. This means that Robin Rombach and his colleagues implemented this diffusion approach we just covered within a compressed image representation instead of the image itself, and then worked to reconstruct the image. So they are not working with the pixel space or regular images anymore. Working in such a compressed space does not only allow for more efficient and faster generations as the data size is much smaller, but also allows for working with different modalities. Since they are encoding the inputs, you can feed it any kind of input like images or text, and the model will learn to encode these inputs in the same subspace that the diffusion model will use to generate an image. So yes, just like the clip model, one model will work with text or images to guide generations. The overall model will look like this. You will have your initial image, here X, and encode it into an information-dense space called the latent space, or Z. This is very similar to a GAN where you will use an encoder model to take the image and extract the most relevant information about it in a subspace, which you can see as a downsampling task, reducing its size while keeping as much information as possible. You are now in the latent space with your condensed input. You then do the same thing with your conditioned inputs, either text, images, or anything else, and merge them with your current image representation using attention, which I described in another video. This attention mechanism will learn the best way to combine the input and conditioning inputs in this latent space, adding attention, a transformer feature, to diffusion models. These merged inputs are now your initial noise for the diffusion process. Then you have the same diffusion model I covered in my Imagen video, but still in this subspace. Finally, you reconstruct the image using a decoder, which you can see as the reverse step of your initial encoder, taking this modified and denoised input in the latent space to construct a final high-resolution image, basically upsampling your results. And voila! This is how you can use diffusion models for a wide variety of tasks like super resolution, in painting, and even text-to-image with the recent Stable Diffusion open-sourced model through the conditioning process, while being much more efficient and allowing you to run them on your GPUs instead of requiring hundreds of them. You heard that right. For all devs out there wanting to have their own text-to-image and image synthesis model running on their own GPUs, the code is available with pre-trained models. All the links are below. If you do use the model, please share your tests, IDs, and results or any feedback you have with me. I'd love to chat about that. Of course, this was just an overview of the latent diffusion model, and I invite you to read their great paper linked below as well to learn more about the model and approach. Huge thanks to my friends at Quack for sponsoring this video.
So there's a lot of technical stuff baked in. I'm sure most jurors will never understand. I'd even say most judges will never understand. I think even most computer science majors won't understand it. And the real question ultimately is, but regardless of whatever steps are occurring, isn't there a base of copyrighted information that is being used without permission, period, full stop? And without which you just could not get to the output that you're generating?
Okay, you've said it there. Copyrighted information, which is being used without permission. Question, is every use of copyrighted permission a use that requires permission?
No, because we know there's fair use. We know that
there's fair use.
Extraction. Like, we know that there are things you can do once something is published. You can extract ideas. You're entitled to do exactly what your wife is doing, which is clip pieces, rearrange them, transform them, create them into something new.
Right.
We all do that. I mean, we all do that in our work daily.
We do it and we want to do it and we don't want the law to interfere with it.
Right.
And when we're talking about a million images instead of one image, the issue becomes even clearer. Of course, we can use a million images because no one image creator has a claim on what we end up with.
Right. That's you put your finger on what may be the best defense argument, which is, look, we probe millions and millions of images to create this model of extrapolation that is something that we create and generate. That is not an exact copy. It's not even a derivative of any of those millions.
Right.
Essentially taking what they would like to say are the principles of abstraction. And we're just doing it all in software, the abstraction, the filtration, the complete extraction of what it is or diffusion of what it is that represents a particular scene.
Right.
That unless you're Getty Pictures, so Getty Pictures may have the better argument because they're claiming that the watermarking is copied as well from the actual Getty images. And of course, they are watermarking and, from a technical point of view, tagging their photographs in a way that allow them to do tracing, whereas most of the rest of the internet they don't really care to do that. Getty's just been ahead of the curve. So Getty may have the stronger case against Stability AI than these class action plaintiffs do.
Adding the meta information to the image doesn't really, in my opinion, change the range of what's legal to do with the image. You know, just because I added my name to it or my metadata doesn't give me more property interest in it. Does make it easier for me to prove what happened to it. But I must say, when these guys scrape, when Stability scrapes 1 million images, they don't have to remove the metadata. The metadata gets crunched and, you know, dissolved in that process. So I don't think they have to remove it. It may make it a little easier for them to work with it, but even if they didn't go to any special effort to remove it, the result would be the same.
So let me give you this hypothetical. Let's say there's 100 treatises on fiduciary duty law. There probably aren't even 100, but let's pretend that there's 100 published in California about California fiduciary duty law, and you're one of the 100. And let's say it's provable that ChatGPT actually did take your treatise, which I think is like 600 or 700 pages, maybe more. You have the exact number. It grows daily. It's a great treatise. And it collapsed it and 99 other treatises of similar length, maybe shorter, maybe longer. So it was basically thousands and thousands of pages, maybe 100,000 pages, into this ginormous database. And then it decided to do this diffusion process of, let's see if we can abstract some table of contents. Let's see if we can abstract some black letter law. Let's see if we can create a summary. And it generates a pretty good version of the Cliff Notes or abstract version of this 100 treatises of 100,000 pages.
Right.
Do you and the 99 other authors have effectively a class action claim? Because more than 35 plaintiffs, it's hard once you get over that number not to call it a class. Do you have a class action claim against ChatGPT?
I don't feel so. And by the way, my treatise, when I was a young lawyer, I read Witkin and studied it, and Witkin was a huge influence on me. But today, in today's world, nobody wants to write a Witkin style anything. It's old fashioned, and I don't know how long my treatise will ever be read. And I don't think we do have a class action. But hopefully, my treatise will be more attractive than the resulting treatise from this AI thing. It will have more charm, maybe more cogent arrangement, maybe. It's an interesting question, isn't it?
Well, remember, I gave you the hypothetical where there's 100 authors. Right. They're all live. They all registered their copyright. They're all upset. Maybe most aren't, maybe some are not, but let's say all are upset. They've got to put on a contingent fee. The lawyer's like, look, you should be getting a royalty for that summary. And I'm going to try to get it for you on a class action basis against OpenAI because they generated this tool that generated this summary. And it is displacing sales. Let's say the sales showed that the 100 authors would typically get $1,000 a month each. And the sales after this came out dropped to like $10 a month each, dropped by 90%. So you could see that lawyers using ChatGPT trained specifically on this database, very subset. It's not the big, ginormous entire internet of all writings. It's specifically these 100 treatises. They are all being targeted. And the lawyers are like, look, the tool organizes it, it creates arguments, it creates citations, it gives me everything for free. I don't have to pay multiple authors. I don't have to pay Westlaw. I don't have to pay Lexis. I don't have to pay any online provider. I don't have to pay the authors. Just basically take advantage of what's being done. But we have a very localized group of works. It's you can manage it to some degree. Now, I think your point is it really depends on if they're abstracting at the level of idea and not my expression and not the expression of the other 99 people. We have to live with the fact that those are ideas. They're public. They're published. They're in the published cases.
Well, in
right?
my case, there's some interesting questions. For example, I have fairy tales at the end of my book. Jack and the Beanstalk, an Arab fairy tale. Is that copyrightable itself if they then put fairy tales into their book? It's a good question because nobody did it before me that I'm aware of.
Well, did they just recreate and copy your fairy tales, or take the concept of a fairy tale as a way to express a fiduciary principle and then they re-expressed it?
The latter, probably.
Well, if they re-express it, you might be in this area that's called scenes affair, which is
yeah.
It's just the way people do a love triangle. It's the way people, parables. It's the way Christ taught in parables. It's just the way people back in the day wanted to hear a story. People today want to hear a story. But in general, to me, if that case, the case I gave you,
Yep.
which is 100 authors with 1,000 page average treatises, 100,000 pages, admission of, yes, we had that data. Yes, we crunched it. Yes, we extracted from it. If that can't win, if you can't win that case, you can't win the case that the class action lawyers have brought.
You're right.
Of all registered copyrights.
You're completely right.
Right? If you're just thinking about it, if you're just trying to think, this is how Mel Nimmer, when I was his first year mentee at UCLA, would talk. He would say, let's look at the simple case first. What if we have this simple case? Can plaintiff prevail in this case? Plaintiff can't prevail in this case, then he can't prevail in a whole other list of cases, right?
Right.
I mean, that's just the normal part of legal reasoning. So that probably is why, to some degree, Judge Orrick in San Francisco on July 19th, verbally, but you won't find it yet in the online system, but it's reported by one of the lawyers in the legal team, Mark Lemley, said, we had a good day in court for the defense. They're representing Stability AI, or one of the co-defendants. I think Stability AI, this is the case that's got multiple co-defendants in it. So the judge agreed to throw out most of the complaint, except the first cause of action that deals with what you properly note as the transient copying, the initial step copying to get to the point of extraction. The judge said, well, there was no motion to dismiss on that, so that claim stays in, but now I'm going to rule on all the other claims. And I think that his thinking is the tracing is not demonstrated sufficiently to actually say expression has been copied. It's been glommed over. And in the case of the 100 authors of fiduciary duty law treatises, 100,000 pages total, 1,000 pages apiece, the defense could be exactly the same thing, which is, hey, we just abstracted and condensed and rewrote and represented black letter law principles.
I agree with that. That's my instinct. I was asking, do you have a case like this in your office?
No, but I'm just thinking that's the problem. When you talk to a plaintiff is often outraged, and the 100 authors who saw their royalties drop from $1,000 a month to $10 a month, they would be outraged, saying this has real economic harm. This is not fair use. This is displacement. This is just as bad as the ad that we saw a few minutes ago where the guy said, well, I take somebody's book that's doing really well and then I turn it into a summary and I create an audio from the summary, and all of a sudden I've got all these information products that are creating revenue for me. And that's outrageous if you think about it. I mean, it's like blatantly saying just rip off best-selling authors, but pretend like you're helping them. Pretend like you're just helping them get the word out about their work, and maybe they won't care. Maybe they won't be bothered. And that's essentially being taught online as something that you should do. That's not the way I grew up. I didn't grow up saying, well, let's copy somebody else's work. That was viewed as plagiarism.
Right.
That was viewed as you get thrown out of school for doing that.
That's right.
But now it's, hey, this is called Amazon marketing. This is called merchandising.
Right.
It's called being an entrepreneur.
That's
Now,
right.
that's far worse to me than this idea of a very powerful AI tool that actually is creating a level of convenience that does have a displacing aspect to it. And I have to believe that the Westlaws of the world and the Lexuses of the world are also very worried about this exact issue, right?
Yes. I agree.
They're big publishers. They want to get their monthly subscription fee. And if this system works so well, why would anyone pay Lexus a monthly subscription fee? Why would they pay Westlaw a monthly subscription fee?
Right.
Doesn't make sense to me.
That's right.
So they've got to be shaking in their boots, and maybe all publishers are to some degree. I mean,
I think so. We're going into a new era, I think.
And is the displacement just too fast, too soon? Like, just, it's okay, but you know, if you look at the way computers did it, it took years and decades, and now it's just shrinking, where things just happen just way too fast for people to adapt, to move in different directions. I mean, at some level, is that the problem? It's just happening too fast. There's a exponential element to this that doesn't give enough time for people to adjust and to rearrange their lives and to rearrange their careers. Because look at the other message in the video. If you're studying programming, maybe, which of course we all thought, yeah, if you want to be completely safe, being a computer programmer, the demand is going to continue to go up. That was the saying just a few years ago, literally. Now it's 41% of what's on the internet or on GitHub is generated by AI. I mean, that's probably going to become 81 or 82% in the next few years.
Right.
What does it mean for programmers? It can't be news, right?
Very interesting. Very interesting.
So I don't know if Judge Oreck, he's a really smart guy. I know less about the Delaware judge. It seems to me that Getty has the better case. At least it seems to me Getty's case has more structure to it, because they could argue that they are probably seeing a real revenue drop on the use of their images, because why buy an image from Getty if you can generate an image that's just as good for free? And say, I generated it and no one told me that I had to pay anything. I mean, I don't know what the indemnification provisions are. I don't know how that's all going to work out when the lawsuits start coming through. But if you're an independent contractor generating websites for people and you don't have beautiful art, like the art that your wife allows you to use as your background there, which is gorgeous.
Yeah.
You probably want to generate a piece of art or something to put in the background, and you don't want to pay a royalty for it. And the royalties can be high. I mean, Getty is in that business of getting paid royalties for its images.
Right.
So to me, this is an existential lawsuit for Getty, and they must be treating it that way.
I think so.
They obviously decided to file a case, and they've hired some really big New York law firms to do it.
Right.
So we've got two cases. We have a Copyright Act that doesn't really deal with this problem directly and specifically. We don't have any legislative proposals yet, although people are talking about that's going to happen. We have two district judges, one in Delaware and one in California. The California case is a little further ahead because there was a motion to dismiss. There is a pending ruling that's about to come out. I'll get it to you as soon as I see it. and we have a bunch of procedural motions dealing with venue and jurisdiction in Delaware. My guess is the Delaware judge probably transfers the case to California and says, hey, one judge, one appellate court, let's not, I don't need to be the guy that, or gal, I don't know who the judge is there that decides this. I've got other things to do. Give Judge Orrick the case. He's already got one that has 3 defendants in it. So just add this to his docket. And I don't think it's one trial because it's really 2 different cases, although they're similar. But it is presumably a set of trials that will result in a set of appeals that go to the Ninth Circuit. Now, if it stays in Delaware, that case will go to the Third Circuit. And then you have the risk of the Ninth Circuit and the Third Circuit not agreeing.
And then we have the Supreme Court.
Which can happen depending on if the Ninth Circuit leans towards the copyright owners or leans towards the technology providers,
right,
or vice versa in the Third Circuit. And from there, it goes to the U.S. Supreme Court. And
right.
So far, if you want to take any recent precedent, the suggestion would be from the case involving that photograph of
Warhol, Goldsmith versus Warhol.
Yeah, and the Purple Rain guy. What's the performer that was formerly called Prince?
Yeah, that's the Goldsmith versus Warhol. Yeah,
that case.
Yeah,
it looks like the Supreme Court's leaning towards the copyright holder, saying you have to pay a royalty. If you take the general principle of that case, that that's a copy.
But that's a really good example because it's one image, it's a clear, unabashed copy with modification. It's not a million images and artificial intelligence doing something.
Right.
That was Warhol's expression.
Right.
According to, who was it, Justice Kagan, Justice Sotomayor was a vigorous dissent in that one.
It's a much easier, it's a far easier case.
Far easier.
With no real technology element.
No. Right.
Right. This is much more of, we have a machine that is a vacuum cleaner on 99% is not copyright registered. Probably over 90% is not really even, may not even have copyright notices or anything else. So there's arguably, quote, innocent infringement that arises from it. I mean, you literally would have to, if you're somehow saying there's a minefield here, you'd have to say, if it has a copyright notice on it, don't vacuum it. If it's registered for copyright, absolutely don't vacuum it. Like basically there could be some filtration around other work that is there to be taken advantage of, and people are in favor of it. And the argument is that's more of a communistic society view, which is if you give to the commons, then it's available to the commons. And maybe all those folks are like, that's great. The progress of science goes forward. And all the others are much more in the proprietary camp. And maybe there's a set of tools or a set of platforms that pays them a royalty, like Apple would. Like if Apple comes out with a version of ChatGPT, my prediction is they'll figure out a way to get royalty payments to be part of it. And to say to authors, put your stuff into our repository. We just want quality in our garden, like the same garden notion that the App Store is Apple's garden, and Apple Music is very curated. And maybe say this is where the higher quality stuff goes. So if you want to use Apple GPT, let's say that's what they call it. I don't know. They were supposedly working on it. They may be in this completely different camp of, this is a good thing, and we'll pay for it, and we'll get higher quality work as a result. And maybe that's the way the world divides into much more of the higher quality versus the lesser quality, and a bunch of stuff.
Underlying that distinction is the fact that art is not intended to give the viewer what he expects. It's intended to give the viewer something unexpected. That's what real art is. And these artificial intelligence image generators are preoccupied with giving the viewer what he expects. So
Yeah,
that's another.
The French would call it, that's called American cheese.
Yeah, American cheese.
That's a block of yellow cheese that's formulated by Kraft to be
exactly
consumable. It's not cheese.
That's
the French would say that's not cheese.
That's exactly the point.
And it's exactly the point. And I have to believe someone in France will do a podcast or tutorial or something about this in which they say it is not even art. Don't even call it art. Don't even call it a creation.
Right. I mean, that's one view of it. It's very interesting, Jack. This is a very, as you point out, it's a topic that hasn't yet been formulated.
And I think if Mel Nimmer isn't spinning in his grave, his son, who's still alive and who still is on the copyright treatise, but so far I've not seen Mel's son, David Nimmer, say anything about this topic.
Have you spoken to him?
I have spoken to him, but not recently. He's with Irella Manella. You know, Mel Nimmer had a long relationship as well with big law firm. I want to say it was Irella Manella as well in Los Angeles.
Yeah.
And I don't know if the politics, I can't say for sure, like the law firm may constrain people. I don't think Mel ever felt constrained, but just generally speaking, this is an area where someone of the stature of Mel Nimmer, and maybe his son will step up to this, David, if you're listening, I hope you do, will come out with a chapter that will be specifically on all of these recent AI developments, a new chapter, and will be the pace setter for the judges who have to decide these cases. Because guidance here would be immensely well received. And it doesn't have to take a slant. It seems to me it can give both sides of the argument and ultimately leave it to the court to decide which way to go on a specific case. But in general, all of the clashing policies of the Copyright Act, both to promote science and art, as well as to reward authors in a way that makes sure that promotion occurs, and to better all of us, are all present in a very big way.
Yeah.
So you know, we have all those policy issues really coming to a head. And again, it's technology that's causing the disruption. And
maybe you and I should write the chapter.
Well, I think it would be great. I mean, I think that would be a great thing to undertake. My question is, will it get the audience? I mean, I'd be happy to work with you on it. I think it'd be a fun thing to do in any event. I do think that there's going to be a lot of confusion at some level, and it requires some degree of simplification to think through the ways to think about a case and the ways to think about traditional copyright versus what might be some new version of copyright. Because ultimately, I think the class action lawyers are saying we have a lot of small proprietors who are totally getting hosed here, who are not getting the value from their work that they should be getting. I mean, it is almost like class warfare. I mean, obviously, Getty Images is much more like the capitalists going after the other capitalists, but the class action case is much more like the proletariat saying, wait a minute, you are reaping from where you haven't sown, and we are not getting even a fraction of the profits. And there's something wrong with that.
That's right. It's a very interesting set of issues. I mean, let's think about it. Maybe we could publish in a law journal or the Daily Journal or some other place.
It's really 21st century copyright. It's really 21st century copyright. And where can it go? Where can this potentially go?
I agree.
Well, you certainly should get to sell more treatises as a result. I'll give you that, because if anything, you've got one of the best fiduciary duty treatises out there, and it's available online too. It's the Law of Fiduciary Duty, and it's available from you at, what's the website, chodos.com?
Well, fiduciaryduties.net.
Fiduciaryduties.net. So I highly recommend it. Well, thanks, Raphael, for coming.
Thank you. Okay.
And soon. I'll keep sending you stuff as I see it.
Oh, yeah. I have a lot of reading assignments. Very good.
There's a lot of stuff going on, and it's going to continue to happen. So it's a great time to be alive.
Thank you for it.
You're welcome.
Okay.
Bye-bye.
Take care.
Tune in next time on The Valley Current.